Welcome to Talking Business, your straight talking guide to dealing with corporate matters. I'm Sophie Brooks, a partner in the Gately Legal corporate team. Each month, I'll bring you a roundup of the latest corporate developments, whether that's interesting cases, new legislation, or relevant guidance. So, if you're a director, a company secretary, or general counsel, this podcast will make sure you're up to date with all things corporate. Hi everyone, I hope you're all well, ready for some more corporate updates. So this month I've got a couple of cases, one involving a possibly fraudulent disclosure letter, another about a transfer of shares made in breach of a company's articles, and then as well I thought I'd maybe just mention a summary of the proposals that have been made to try and zhuzh up AIM. So let's start off with a recent case. So this one was all about whether statements made in a draft disclosure letter could amount to actionable representations. And it was a summary judgment application. The court held that the claimant's action for fraudulent misrepresentation had a reasonable prospect of success, and therefore whether the draft disclosure letter did contain actionable representations was a question that needed to go to a full trial. Now, although it was only a preliminary hearing, the judge's comments about the nature of disclosure letters and the resulting implications for misrepresentation claims are potentially significant, which is why I thought it would be a good one to discuss. So, if you didn't know, it's standard practice in an M&A transaction for a seller to give warranties to the buyer about various aspects of the target business. So those warranties are basically contractual promises or assurances about the business that the buyer is acquiring. So if a warranty turns out to be untrue, then the buyer might have a claim for damages against the seller. So one of the principal ways that the seller can try to limit their liability for breach of those warranties is to disclose against them. And then the seller won't be liable for a warranty claim to the extent that the circumstances constituting the breach, so the relevant thing, the matter, has been disclosed in advance to the buyer. So disclosures are usually set out in a separate disclosure letter from the seller to the buyer, and that draft letter will be continually updated and negotiated throughout the course of the transaction. So the seller will typically view a disclosure letter as a means of protecting itself from liability, and it won't want the buyer to have any additional claims based on just the disclosed information in that letter. So you can think of the warranties as being the buyer's sword, in which case the disclosure letter is the seller's shield. And what the seller doesn't want is for that shield to effectively become another sword for the buyer, if that's not stretching a metaphor too far. So the disclosure letter often contains an exclusion clause along the lines that the disclosure of any matter will not amount to any representation or warranty that's not already given in the acquisition document. So that's trying to stop the buyer being able to claim for those things that have been disclosed. Now, in this particular case, we were dealing with the sale of a health company. And during negotiations for the acquisition, one of the target company's most important customers triggered a price review mechanism, allowing it to switch suppliers for a particular pharmaceutical product if the company failed to match a competing price offer. So, a few days after the share purchase agreement was signed, the target company matched a competing offer at a significantly lower price than it had previously been charging that particular customer. So, after completion of the acquisition, the buyer alleged that it had been misled about the target company's relationship with this particular customer. And it brought various claims against the seller, including for breach of warranty and for fraudulent misrepresentation or deceit. So the misrepresentation case was based on a draft of the seller's disclosure letter, which stated that no competing offer had been notified to the customer and that it was not possible to quantify the impact of ongoing price negotiations. But the buyer claimed that those statements had been made fraudulently because the buyer said the seller was aware that they were untrue at the time they were made. And therefore, the buyer said, well, they are misrepresentations, and the buyer had relied on those misrepresentations when it acquired the target company. So that's the claim by the buyer. The seller then applied for summary judgment, so basically trying to knock out the buyer's claim at the first hurdle, if you like, on the grounds that, firstly, a disclosure letter couldn't give rise to representations because the only purpose of the disclosures was to qualify the warranties. And then, secondly, the other limb of the seller's defence, if you like, was that the disclosure letter included an exclusion clause. And that said, the disclosure of any matter in the disclosure letter shall not imply any representation not expressly given in the share purchase agreement. So, when that application for summary judgment came before the High Court, the court dismissed it on the basis that the buyer's fraudulent misrepresentation case had a real prospect of success at trial. And the judge said there was no legal rule about what can or can't amount to a representation when parties exchange what are to become contractual documents. The only established principle in relation to that was that the provision of a warranty would not, without more, amount to a representation of fact. Now, the judge acknowledged that the primary function of a disclosure letter was to qualify the warranties, but he didn't think that it was impossible for a disclosure letter to also provide factual information that the recipient, the buyer, might reasonably rely on. And whether the draft disclosure letter in this particular case contained actionable misrepresentations was a question that would require an investigation of all the relevant facts, and that required a trial. So it wasn't appropriate for a summary judgment dismissal. So even though this was just a preliminary hearing and we haven't had a full trial of all the facts, I think the decision's maybe just ringing a slight warning bell for sellers because it leaves open the possibility of statements that they make in a disclosure letter could be construed as representations and therefore being susceptible to claims for misrepresentation to the extent that they're not true. Um, that means that a buyer might then be able to sue for breach of a warranty when the disclosure has not successfully qualified the warranty, and or for misrepresentation if the disclosure itself is untrue. But I think it's worth noting that in this case, the buyer was alleging deceit by the seller. And that was relevant as to whether the seller could effectively exclude misrepresentation claims. So the judge acknowledged that if there hadn't been any fraud, then the contractual arrangement, so that exclusion clause in the disclosure letter that I mentioned and also provisions in the share purchase agreement, may well have prevented the buyer from claiming misrepresentation in relation to the disclosure letter. So that perhaps might slightly reduce the noise of that warning bell for sellers going forward. But in any event, I think it's a useful reminder to sellers of the importance of always ensuring that any statements in a disclosure letter meet whatever the agreed standard of disclosure is in a particular each case, and that the sellers believe that all disclosed information is indeed true and accurate. And we will have to see and await the outcome of the full trial, if indeed the case proceeds to a trial, if it's not settled earlier, um, with great interest to see what impact that's going to have for future cases. Okay, Next up, I thought I would just mention the proposals by the London Stock Exchange for reviewing AIM. They've issued a discussion paper called Shaping the Future of AIM, and they're looking for feedback there about the overall functioning and positioning of AIM. And in addition, there are specific proposals about changes to the AIM rules. So AIM, it was originally called the Alternative Investment Market when it first appeared, but it's now known just as AIM. It's been a central feature really of the UK capital markets for over 30 years, and providing early access to capital for growth and founder-led companies. The discussion paper aims really to generate some debate with the objective of AIM retaining what the LSE calls its jewel in the crown status and remaining the leading European growth market. So this review, I think, of AIM is another step in the ongoing evolution of UK capital markets that's been taking place over the last few years. We've already seen the adoption of new UK listing rules last year, 2024. We've got reforms coming up to the UK public offers regime, and we've seen the introduction of PICES, so a new market for the secondary trading of shares in unquoted companies. They're all things that we've featured on the podcast previously, and I think this one, looking at AIM, is just the latest development. And like I say, the discussion paper seeks feedback on the overall market framework and the products and services that support AIM companies and their investors. The LSE says that its top priority, which no doubt will be welcome news to AIM companies, is to increase the flow of capital into AIM and to maximise liquidity by ensuring that that capital comes from a diverse range of sources. And with that in mind, the LSE is asking for views on the current package of fiscal incentives which are designed to encourage investment in AIM. So that includes things like EIS, Enterprise Investment Scheme, VCT, Venture Capital Trusts, ISA inclusions, business relief, which is available to investors in qualifying AIM companies. But they're also looking for additional suggestions for other interventions that could support that flow of capital into AIM. In relation to AIM's regulatory design, the LSE has confirmed its view that what we call the nomad, the nominated advisor role, is really central to AIM's success. So we're going to be keeping that role, but they are looking at views on how it could evolve to reduce costs in particular and ensure that nomads continue to provide value for companies. So that's going to involve highlighting areas of the admission process, maybe where there's duplicative work, particularly between the nomad, the lawyers, and the reporting accountants. And then in relation to corporate governance, the exchange has already received feedback from some AIM companies that they don't really feel they have an appropriate choice of code for their particular stage of development. So again, we're looking at views on whether maybe as an alternative to existing code, so like the UK Corporate Governance Code or the QCA's code, whether there could be a simplified list of corporate governance requirements for AIM companies, and indeed, if there is, then what those particular key requirements should be. So that's kind of the overall sort of framework. But then the discussion paper also wants to explore how the LSE could evolve the AIM rules. So that's the set of rules to which AIM companies are subject in order to reduce unnecessary administration burdens and cost, but whilst also keeping aspects that remain important for investor confidence. So there's a balance there, getting it right between enough rules and regulation to have that investor confidence, but not unnecessarily burdening the companies themselves. So there are various proposals set out in this discussion paper. So things like offering an alternative simplified admission document for AIM that could reduce the cost of admission, maybe not requiring working capital statements in certain circumstances. Then things like exempting certain transactions from the related party requirements in the AIM rules, and also increasing the substantial transaction threshold in the class tests from 10% to 25%. So basically, that would mean that those rules in relation to substantial transactions would catch fewer transactions. And then, maybe most significantly for potential new entrants, and also aligning AIM with the founder led nature of growth companies, then the stock exchange is proposing to permit admission on AIM of dual class shares. So replicating the structures that are now permitted on the main market so that founders can retain a special class of shares and retain more control than has previously been permitted. So that's kind of a bit of a whirlwind tour of the proposals in that discussion paper. Responses have to be in by the 16th of June, and then following that, the London Stock Exchange will consider feedback and then hopefully consult on proposed changes to the AIM rules. Okay, then finally, the last case that I thought I would mention was one in which the High Court refused to remove a shareholder's name from a company's register of members, despite the fact that that registration had been done in breach of the company's articles of association and in excess of the director's powers. So in this particular case, the court said, well, actually, the shareholder was a person dealing with the company in good faith when the share transfer was registered, meaning that the company could not rely on the director's excessive use of powers to contest that registration. So the case involved a company that had agreed to sell some of its shares out of treasury to an investor. So the shares were being held in treasury because they'd been bought back by the company from another shareholder. So if you like, it's slightly odd, but the company effectively was holding shares in itself, and it was those shares which the company agreed to sell to an investor. So the company's articles of association prohibited its directors from registering a share transfer until the transferee of the share, so the new shareholder, the buyer, had entered into a deed of adherence, agreeing to be bound by any shareholders' agreement that was then in force at the time of the transfer. Now, in this case, at the time of the proposed transfer, the company and its shareholders were indeed parties to a shareholders' agreement. So that meant that the investor had to execute a deed of adherence to that shareholders' agreement before the share transfer was registered. Now, the agreement included a compulsory deed of adherence that had to be signed not only by the new shareholder as transferee of the shares, but also by the company and its other shareholders at the time. So the investor did indeed duly execute a deed of adherence, and the company and one of the other shareholders also did the same. But there was another existing shareholder that didn't execute the deed of adherence. But despite that, the company proceeded to update its register of members to reflect the share transfer to the investor. Now, sometime later, the company brought an action to rectify the register of members to remove the investor as a shareholder. And it did that on the basis that the deed of adherence was not effective, meaning that the investor had not become a party to the shareholders' agreement and the share transfer had therefore been registered in breach of the Articles of Association. But the investor argued that even if the transfer had been registered in breach, it, the investor, was protected in its dealings with the company under a particular provision of the Companies Act, Section 40, because that protects third parties dealing with the company in good faith where the directors act beyond their powers. So in this case, the court dismissed the company's application for rectification of the register, even though it did actually find that the directors had indeed acted without authority when they registered the share transfer to the investor. So, in relation to the director's breach, the court held that the company's articles of association required a legally effective deed to bind the investor before the directors had power to register the share transfer. As the deed of adherence in this case was conditional on all the parties executing it, and like I said, one of those parties didn't do that, the deed was not legally binding. So that meant that when the company's directors registered the transfer, they did without authority and in excess of their powers, because they were only supposed to do that once the new shareholder had signed that deed of adherence to the shareholders' agreement. So that was it in relation to the director's breach. But crucially, the court then went on to find that the company couldn't rely on that breach to contest the share registration and remove the investor's name from the register. And that was because that section 40 that I mentioned, that applied to the transaction. And because of that, the directors were deemed to have unlimited powers to bind the company in favour of a person dealing with it in good faith. So the judge confirmed that that section 40 could apply as much to a shareholder as to an unrelated third party, provided that the shareholder was a party to a transaction with the company and the shareholder was acting in good faith. And good faith was to be presumed unless the contrary, bad faith, was proved. And the fact that a person was aware of a limitation on the director's powers, so the shareholder might have known about that limitation, that didn't automatically mean that they were not acting in good faith, that they were acting in bad faith. So, in relation to whether or not it's a transaction with the company, in this case, the investor unusually had negotiated its acquisition of shares directly with the company, because although it was a share transfer, remember, it was acquiring those shares out of treasury. So that did amount to a transaction with the company, and the registration of those shares by the directors wasn't a standalone act, but it was a final stage in the acquisition process. So, on a practical level, I think that case illustrates the importance of all the parties fully understanding a company's prescribed procedure for the transfer of shares, whether that procedure is detailed in the Articles of Association or a shareholders agreement or some other similar document. It's not unusual for an incoming shareholder to have to sign a deed of adherence if there's a shareholders agreement already in play. But it is a bit more unusual for all the other shareholders to also have to sign that deed before the share transfer can be registered. Because if you think about it, that effectively gives all the other shareholders a right of veto over the share transfer, even if it's a permitted transfer under that shareholders agreement or under the Articles of Association. It's kind of giving them an extra an extra veto. So I think, as well as that, the case is also a good, useful clarification that Section 40 can be used to save a transaction between a company and its shareholders. But this only applies if a person is dealing with the company in good faith. Now, the investor was fortunate that it satisfied the dealing test here because it had bought the shares directly from the company. And that's why Section 40 was engaged, because it was a transaction with the company. If, as is more normally the case, on a share transfer, the investor had acquired the shares from an existing shareholder, then the registration of the shares alone wouldn't have amounted to a transaction with the company. The transaction would have been between the two shareholders, and if you like, the company registering the transaction would have just been an administrative step. And then in that case, Section 40 wouldn't have been in play. It wouldn't have prevented the share transfer from being unwound. So that's it for this month. Hope you found those cases and that review of the proposals in relation to AIM interesting. I will see you next month. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.